Also in court today, prosecutors showed pictures of what investigators found inside Ernest's car after that 911 call. That included the gun, tactical helmet, and magazines. They say investigators also found cleaning and nursing supplies. When they laid out the weapon for evidence, they counted a total of 5 magazines, each with 10 rounds.
Joining us to break down this case is legal analyst Gretchen Von Helms. Thank you so much for being with us.
Thanks for having me.
So we saw at the end of Mackenzie's package, Ernest made some facial expressions. He turned, he smiled. Could that affect this case?
Right, yes, you don't want your client to be making any gestures. I don't know if he was gesturing to his own family in court or to a victim's family. You never want to have contact like that with the victim's family, certainly. So I'm sure his lawyers will admonish him to not do that sort of thing, as will the court bailiff.
Now, is there any kind of impact this actually could have legally in the trial when he's doing things like that?
Well, yes. Well, so when he said the trial, the jury watches everything, and they take that sort of thing into consideration. You know, if he's, some jurors will say they're smirking or they're making faces, or and they could misjudge or prejudge what he's trying to communicate. And so it's not a good idea to communicate via hand signals that could be misinterpreted or interpreted in a bad way.
There's a 911 call, there's surveillance video, there are witnesses. If you were his defense attorney, what route would you take?
Well, this is a very difficult case for the defense. Obviously, there's a lot of evidence in the case that indicates that this person might be the culpable person, but there is a plausible defense. He may not have been right in his head, if you will. There may have been a legal reason that he did these things that will enable him to be found not guilty by reason of insanity. What that means is he goes from one box, the jail box, to another box, which is a lockdown box for people who have mental problems and do this type of case. So it doesn't mean he walks free on the street, but there is a way to defend this case that they have to explore.
Now, will we, I guess, know that during the course of this preliminary hearing?
Probably not. Too early at the preliminary hearing, but later on as they prepare for his trial, his lawyers will be looking for things that they can do to attack the prosecution's case. Remember, the defendant doesn't have to do anything. He just sits there. It is the government's job, the prosecution's job, to prove the case and remove all reasonable doubt. So if there is doubt there, the jury must find a person not guilty, no matter how heinous the crime is. That's a very important point. We as citizens think, oh my gosh, this looks terrible, right? But jurors have to do what one judge calls mental gymnastics. They have to be very mathematical, very analytical, and they have to look at each piece of evidence clearly.
Legal analyst Gretchen Von Helms, thank you so much for being here with us.
Thank you.